Mayor, my lord. My lord, I beg to mention one unlisted bail application for today, my lord.
Okay.
Yes. Deeply applied.
May I please, Lordship?
Yes.
Lordship, I beg to mention item number 3, Lordship.
Item
That Lordship, my senior.
item 3. Item
Item number 3, Lordship.
for admission. Admission or
This is
hearing?
for hearing, Lordship, but my senior counsel is out of station. She is on leave, Lordship.
What is item number 3? Item number 3 is for admission.
Yeah, it's for admission hearing,
Yes.
Lordship. But Lordship, my senior
You
counsel.
mention when the item reaches, no?
Maybe,
Okay.
Lordship. Deeply, Lordship.
Yes.
Here is a criminal petition 103 and 129, and it is mathematically released tomorrow because there is an urgency because leading counsel is coming from Guwahati tomorrow, and there is some other cases also is fixed for tomorrow. It's
Have you
mathematically
informed the other side?
yes.
For tomorrow.
Much available.
Lordship, I beg to mention item 6.
You talk to the
Oh.
mic.
Item number 6.
Item number 6.
Conduct council out of station, so matter may fix after 2 weeks.
Leading counsel is out of station. So when do you want it?
After 2 weeks.
Other side, no objection.
No objection, Lordship.
Heard learned counsel, Shri, your name?
Nani Kuru.
Your name is here in the
Yes.
cause list.
Yes. Nani Kuru.
Nani Kuru.
Item 6.
Okay.
For respondent.
Nani Kuru, okay, for the respondent, submits that the leading counsel is out of station and accordingly prays for listing the matter after 2 weeks. The counsel for the appellant has no objection, list the matter after 2 weeks.
Ma'am,
Yes,
Lordship, I beg to mention item number 14 and 15.
14 and 15.
Yes, I was supposed to file one IA for both the item. Because of paucity of time, I could not file it. So some further time I give.
IA for what?
Regarding the charge sheet, addition of charge sheet.
Oh, acha. Later charge sheet was filed.
Yes,
Yes, so you have to challenge that also.
I have filed this application regarding the petition regarding the question of FIR.
FIR.
Yes.
Okay, and later charge sheet is already
Yes,
filed.
yes.
Okay.
So 2 weeks time is right.
I heard learned counsel for the petitioner, who prays that he is yet to file the IA as directed by this court. Accordingly, he prays for 2 weeks' time to file the IA regarding the charge sheet. Praise allowed. List the matter after 2 weeks.
Oblige.
May I please, Lordship? Lordship, I beg to mention item number 21 on behalf of Mr. N. Rama for the respondent. Due to health issue, he could not present today, and Lordship may be fixed after 2 weeks.
For R2, respondent,
I'm appellant, he is respondent.
yes.
I
Lordship,
took consult.
Lordship, matter may be this after 3 weeks, because after 2 weeks, I'm from Assam, there is a Bihu
Bihu
festival.
break,
Yes.
yes.
After 3 weeks, my lord.
3 weeks. Learned counsel mentions on behalf of the respondents, mentions that Shri N. Rama, the leading counsel, is indisposed, and accordingly prays for adjournment for 3 weeks. Learned counsel for the appellant is present, and is the matter after 3 weeks for hearing.
Oblige.
Yes.
Lordship, it's a concern from the counsel for the petitioner. I'm saying for the adjournment item number 10. I'm actually for the private.
No, but how can you mention for the petitioner?
I'm for the respondent.
That's
want
why,
the
that's why. Respondent, if you're respondent, how can you say that? Okay, other side.
Now for the petition.
Oh, okay, okay,
I say
okay, you have
consent.
no objection.
No, yeah. 1 week time may be given.
Okay. Heard the counsel for the respondent, your name?
Ivan, it is not there in.
Okay, anyway, heard the counsel for the respondent and praise that he may be given how much time? 1 week's time. To file counter affidavit. Learned counsel for the petitioner has no objection. It's the matter after 1 week.
Mayor, Your Honor.
Yes.
Your Honor, I would like to adjourn the matter since the leading counsel is out of station.
So when do you want? Any objection?
No objection. I'm for that.
And I am for the respondent and later matter may be fixed after 3 weeks, Your Lordship.
After 3 weeks is a baby vacation. So let it be after 3 weeks then. Heard learned counsel for the respondent. Who states that the leading counsel is out of station.
Yes,
Out of
yes, Your-
station. And praise for adjournment. Learned counsel for the appellant has no objections. Is the matter after the Bihu vacation.
applies, Your Honor.
It's-
My lord, I'm representing on the behalf of the CI Matogato. Sir, my lord, he cannot attend today, sir. So I please to adjourn it and give us 1 week.
1 week.
Yes, sir.
You are praying for the petitioner,
Respondent, ma'am.
respondent, petitioner.
Yes, Lordship.
Okay,
I
no
for
objection.
No objection, Lordship.
Learned counsel for the respondent, prays for how much time? 1 week. 1 week's time. As his, what did you say? Your senior? Your senior is out of station. As the
The CI
leading,
Matogato.
as the leading counsel, in the present case is out of station. Learned counsel for the appellant has no objection. No, learned counsel for the, who was adjourning? You are adjourning, nah?
Yes.
Learned counsel for the respondent has no objection. At least the matter after 1 week.
Thank you.
Lordship, I am praying for adjournment, Lordship.
Here also adjournment.
Yes, Lordship.
Why everybody is adjourning
The
everything?
Lordship, leading counsel is out of his station and she is on leave, Lordship. So matter may be fixed after 3 weeks, Lordship.
Appellant, you're for appellant.
Yes, I am for petitioner, Lordship.
Petitioner. Heard learned counsel for the petitioner who states that the leading counsel is out of station. And prays for adjournment for a week. 1 week,
The 2 week, maybe 2 week, Lordship.
prays for adjournment for 2 weeks.
And they have interim order, Lordship, that may be continuous.
The interim order passed earlier shall continue till the next date. Place the matter for admission,
Yes, Lordship.
admission hearing after 3 weeks.
Yes,
2 weeks means Bihu, no?
yes, Lordship. Deemed it, Lordship.
Lordship, I'm for the respondent.
Yeah.
The matter may be adjourned for today, Lordship.
For today.
Yes, no, maybe taken up after circuit. After 2 weeks, Lordship.
After 2 weeks.
Yes,
What's the reason for the adjournment?
Lordship. Here is the leading counsel is having some personal difficulty. That's why.
Learned counsel appearing for the petitioner. Okay,
I'm for the
this
respondent, Lordship.
appearing for the respondent states that the leading counsel, he's from Guwahati,
Not from Guwahati, he's from here only. For Deep Angling, Lordship.
but he's out of station,
Due to some personal difficulty,
personal
Lordship.
difficulty. The leading counsel has some personal difficulties and accordingly matter may be listed after 2 weeks. Learned counsel for petitioner has no objections to the prayer. Stop. Yeah.
The stay order passed on 17th in 2025 maybe
The stay order passed earlier shall continue till the next date. Please the matter after the Bihu vacation.
I realize.
My policeman. Lordship, my senior is standing on his leg in court number 1. Matter may be passed over.
Can we call out after some time?
Yes, yes. Pass over for the time.
Pass out for time.
Please.
Vision. Is it ready? Otherwise, notices, everything complete. Unserved notice in respect of respondent number 4 has been received with postal note address not found. Respondent number 4,
We have taken steps, Lordship, but
returned unserved. So can you take steps by Dusty?
Dusty,
Possible?
My lord, the dusty is not permissible. However, your lordship, they may be directed to take steps through jurisdictional PS, your lordship.
Through the PS,
Yes, your lordship, jurisdictional police station.
take steps through the concerned PS then.
Lordship.
Notice on respondent number 4 has returned unserved with the remark address not found, comma, addressee could not be located. Stop. The learned counsel for the petitioner is directed to take fresh steps on respondent number 4 through the OC of the concerned police station. This is the matter after 3 weeks.
Yes, your lordship.
Highly obliged.
Deeply obliged.
Your Honor, your Lordship, may I plead? Last occasion, order, record from Principal Magistrate, JGB was called for.
LCR. Yes. LCR has come. Principal magistrate, it has come.
Yes.
LCR has come. So we can visit for hearing. The original lower court records are before the court. The cases, otherwise all parties are represented, no?
Yes, yes.
Your Lordship, next date may be given.
Yes.
For hearing.
Wait. What about respondent 4? Respondent 4 is represented. Yes.
Your Lordship, I'm making prayer on behalf of K. Tama, Your Lordship. He has been appointed as an amicus curiae in this case.
For R4.
Yes, yes, Your Lordship.
Hmm.
So in this regard, Your Lordship, since pleadings are already completed, Your Lordship, matter may be fixed for admission hearing in that case.
Commission hearing.
Yes, Your Lordship. Since TCR also received.
What about paper book?
Criminal, this is application under 482.
482, yes.
Oh, okay.
On the last occasion, this TCR was called for.
Yeah, it's come.
Yes, Your
Yes,
Lordship.
it's come.
So in that case, pleadings are already completed.
Yes. Yes.
So maybe fixed for admission hearing.
What did I say last time?
But they find the email.
Have been received. The case. No, don't delete that case. All the respondents are represented, and a prayer has been made on behalf of respondent number 4 to list the matter after 2 weeks.
2 weeks.
After 2 weeks, list the matter for admission hearing after 2 weeks.
I do oblige.
They do.
Item number 9.
Come for the petitioner, Your Lordship. Your Lordship, the service report is completed on dated 23 of February 2025.
But
So,
none appears.
no. Lordship, my small prayer
Yes.
may be listed after 1 week and then amicus may be appointed if the victims are absent.
Let's give them 2 weeks at least.
So, Your Lordship, the matter is pending for a long time. So, yes, there's an IA in this case.
The office note indicates that respondent, the service on respondent number 2, isn't it? Or 4. On respondent number 2 has been served. However, none appears for the respondent number 2 when the matter is called. Accordingly, list the matter after 1 week. In case the respondent number 2 remains unrepresented, the court will appoint an amicus for the same. List the matter after 1 week.
Pleasure.
Item number 11 and 12.
Condemnation. Who's appealing for the applicant? Yeah.
Lordship, this interlocutory application.
For condemnation.
Condemnation of this,
Yes.
that may be condemned.
You are the applicant.
Yes.
So who's appealing for respondent?
Yes.
Any objection?
Yes, Lordship, there is,
Serious objection?
yes, serious objection.
Have you filed your objection?
Yes,
Written
Lordship, I have filed objection.
So can we hear? You're ready?
Yes.
Let him explain first.
Okay, let's see your cause, sufficient cause, where is your?
So, I have given the ground. There is a issue is, objection is, there is a delay in filing 565 days
Mm,
in filing this interlocutory application. This is the issue here.
mm.
Lordship, here, import this, there are certain thing that require to be looked into. This is first of all, there are numerous factors under that situation. He could not file this application. File this revision,
Mm.
and there is a delay in filing this application. First of all, my first ground is Lordship, on merit. On merit, Lordship, there is a sufficient ground.
No, but
If I
when
may
we
allow.
go into merit
Yes,
in the
if I may allow.
application, that's the question.
And second is, Lordship, I have a unmarried sister. Since beginning, there is a health issue, and I am also is during the course of this, the circumstances there was a public ignominy was there. This is with regard to rape matter.
Mm.
That is why this my second ground is Lordship. There was a I have a
No,
one
first,
ill health.
the impugn order, what is the date of the impugn order?
27 October 2022
27,
of October 2022.
10, 2022.
Yes. I have enclosed all the medical reports I'm looking after, I'm an unmarried, from with various interval of the time and so on. This is in technically in the page number, annexure 1, page number 13 of IA, interlocutory application. This is the discharge application of the co-accused, against which this interlocutory this criminal revision has been filed. Because to admit this criminal revision, this interlocutory application filed, because there was a delay in filing the revision. After 90 days, as per the law, this the rest of the days is to be condoned by this honorable court. So, as I have shown
So
in page number
showed
page-
your
yes,
explanation
I'm
from
I'm
20,
trying to
yeah.
trying to convince this honorable
Page
court.
7, 10, 22.
Then next, my line of argument is page number 16, annexure number 2 series of interlocutory application.
Those medical grounds.
Yes, that is the one is medical ground of my mother and my elder sister, who is all the time engaged in the medical medical treatment. And in this connection, all the relevant checkup and follow-up actions has been enclosed in the page number 17. This is the treatment record of the Fiscal Medical College, Bangalore. And then, since that point of time till page number 35, kindly see, the follow-up action is going on the page number 35, the medical report of my mother. He being a donor and always to, she has to look after all those family hardship. Page number 35, annexure 2. This is Yatov Jamu, is my mother. And then again, page number 13, it is 13 March, page number 38, 13 March 2024. Again, I have enclosed this, my father is also there,
Page 30,
page number 38,
38.
yes. T Jamo. This is Tangi Jamo. He is also all age-related ailments is always there, and he has no doctor.
So
And then-
who is this D Jamo, your
T
mother?
Jamo is my father.
Father.
Yes. Being an unmarried daughter, I have to look after all those things. And then, in the meantime, page number 43, this is page number 43. This is in connection with the treatment record of the petitioner. 25 October 2022. 25 October 2022. This is the on October. At that point of time, it was this impugn order is on 27 October 2022, and this is 25 October 2022 in that page. Page number 43.
43.
Page number 43. This is a
So
treatment record of.
at that time you were under treatment.
Yes, I was under treatment because after the incident, rap incident, I was under this mental depression. I was unable to decide. And then thereafter, there is a series of this treatment record in page number 44 of exam, page number
These are
45.
tests only.
Yes, all the
Liver functioning
depression,
tests, lipid
in connection with
tests.
depression, I was undergoing facing this depression problem. And page number 45, 46, 47, this is a bunch of the medical sleeping with regard to depression. Page number 49 is 50, Jamo. And then at the last, kindly see one of my cousins of my father's brother, cousin, he was helping the family and page number 63, annexure 3. Time was running on. Page number 63, annexure 3. I have enclosed the death of my father's brother son, who was staying with us at that point of time to this help in management of the family issues, because all the family members parents are already
Page
too old.
51, I think.
Yes, too old and their ill health, and sister was also ill health, and she herself was also mentally depressed and unable to decide. Then my brother died on this is the death certificate, death of the 29th of January 2024. My cousin, not brother, my cousin of my father's brother, whose cousin, distant cousin. And then in the meantime, the case was, I thought that case is going on very well in the trial court. But in the meantime, there was a miscommunication. I was represented by Miss S.B. Daran, advocate before the trial court, but to assist the PP at that point of time. But I was not properly communicated. That is why she even given her no objection certificate, leaving aside this
Page
case
62.
in page number 64, annexure 4, saying that I have no objection if any advocate is engaged in the side case. That is why all these even circumstances, I could not file the cases within the limitation period. There was a contributing factor involved. That is why, whereas Lordship, if this is case is argued on with the merit, there is a sufficient ground in which this honorable court may interfere. That is why Lordship may condone this application, this delayed period, and admit the case for hearing so that the case is argued on merit. In this connection, I have there is, as per the various FS court decision and all this technical, this Lordship board is to see this prevailing circumstances, under what circumstances the case could not be filed. If there is any reasons, sufficient reason, sufficient is not particularly that some prescription is there, but this honorable court has to see what was the situation, what that may affect this further step of this party. That is why Lordship, without technically even day-to-day explanation, avoiding the technical day-to-day explanation, an explanation has been given in general, saying that these were the circumstances under which case could not be filed, taken up. In a no urgent step could not be taken because there was a miscommunication between the advocate and she was mentally depressed too, and there was a public ignominy because yes, after living together, after promising marriage, there will be marriage as a second wife, then she has been thrown out, and she was not in a position to go in the bazaar. That was the situation. That's why urgent step could not be taken, and illness of the ailing fathers was there. This all parents was there. This father was all the time, all as related ailment was there. And mother is the donor of sisters. This health problem is there. He is a kidney donor, and he has to follow up action is there. All the time he has to recheck up in the outside states. Her sister is also looking after her health. That is why this is the prevailing situation, which is a sufficient ground to admit this case. In this connection, there are a certain lordship Supreme Court cases. May I, yes, sir. This is in brief. I have book is here. Even three citations under what circumstances, in the given circumstances, it is a fit case where this and also citation also I have. There are many such cases which condonation has been allowed in certain cases, in such nature of cases. This is, I have marked out the report, second decision.
You have print out.
Yes, I have a
You
printout
supply
copy.
the printout. Okay,
This is one,
it's admitted position that even the merit of the case cannot be overlooked.
Yes,
But then, in this case, what is the role of respondent number 2 in a 376 case?
respondent number 2 is the respondent number 2 is the person who has asked me for marriage with his wife, her husband, saying that as per the custom, it is in ordinance for this, it is the prevailing as per the prevailing Misi customary law. Generally, this the woman who can marry her husband with the second wife is generally considered a strong woman. That is the issue here. That
So
is why, as
respondent
per the
number
custom,
two,
as per
yeah.
the customs, this petitioner has been called by that respondent number 2 as a second wife.
That's why respondent number 2 is the first wife.
Yes, first wife. She called her, this petitioner, as a second wife to be married with her husband. That is the case.
Okay, let's see.
And this is
This is
one.
1987. You read the relevant paras only.
This one. I have one is
In 87 to ACC, which para?
and 19. State of, I'm taking up this state of Haryana versus Chandramani case, 1996. I have furnished a copy. And it is relevant part in the Chandramani case. Relevant paragraph is page number 4, paragraph number 4. In the paragraph number, may I read the
Yes.
this operator? It is the notorious and common knowledge that delay in more than 60% of the cases filed in the court, be it by private party or the state, are barred by limitation. It is this court generally adopt liberal approach in condemnation of delay filing, finding somewhat sufficient cause to decide the appeal on merit. It is equally common knowledge that litigants include the state are accorded the same treatment and the law is administered in the even-handed manner. When the state is the applicant is praying for condemnation, it is the common knowledge that the account of impersonal machinery is inherited bureaucratic methodology in view. It is generally this paragraph 4 says this in case of such when there is a merit in the case, this court has to see the liberal approach for justice in place of technical approach. That is, in the Sandamani case, in roughly it is this ratio decided by the court is this general approach has to be seen, and decision of the court should be justice oriented. Then there is a sufficient force. That is one. And another is I have cited is 1987 case. 1987 is this is in connection with the collector land acquisition Ananta and other process. Katalji. In this para 3, in para 3, in this para 3, may I read the content, the operative portion. Every delay must be explained doesn't mean that pedantic efforts should be made. Why not every hour's delay, every second delay? The doctrine must be applied in rational, common sense, pragmatic manner. When substantial justice and technical consideration are pitted against each other, cause of substantial justice deserve to be prepared, for other side cannot claim to have vested right in interests being done because of non-delivery delay. Because I am to say in this case also, there was the delay was not deliberate, and this pragmatic approach is to be seen. When the sufficient cause has been made out, then this court is to see that this pragmatic approach under that's in the given case whether to condone the delay or not, that has to be seen. In the paragraph 6, it is said it must be grasped that judiciary in respect on account of its power to legalize justice on technical ground, but because it is capable of removing injustice is expected to do so. Making a justice-oriented approach for the perspective, there is a sufficient cause for condemning the delay in institution of the appeal. That fact was state was seeking condonation and not a private party altogether irrelevant. Doctrine of equity before law demands that litigant include the state or the state according to the same treatment. It is overall this ratio is that when there is a sufficient cause is made out, and the situation was a compelling situation, and there was a nothing any deliberate deliberate ground on the part of the petitioner in delay the filing process, filing this application. Under that situation also, this honorable court has to see there is this ground has to be taken into consideration while deciding this delay period. And this one more case is Ramnath Sahu, 2002 matter. Ramnath Sahu matter is this page number, paragraph number 11, 12, and 13 in the Ramnath Sahu case. This is 2000 current matter. Paragraph 11, 12, and 13. In this case, may I read the contents? This judgment says, as court knows that, paragraph 12, refusal to condemning the delay result in foreclosing a suitor from putting forward his cause. There is no presumption that delay in opposing the court is always deliberate. This court was held that the word sufficient cause under the section 5 of limitation rule should receive a liberal construction so that advanced substantial justice is met. In such and such cases, it is decided in all the cases, it was decided there should be a sufficient cause and there should not be any attempt on the petitioner part that the delay was deliberate. Unless delay was shown to be deliberate, then it is a sufficient cause. When there is a sufficient cause, the decision of this honorable court has to this admit this case and while condoning the delay period and matter can be here on merit so that justice is prevailed. This is the situation. I have cited 4 cases in this. All the cases there should be liberal approach.
Similar.
From my part, I have proved that there was an illness on the part of his her elder sister who is the kidney this recipient of the kidney and all the time he is a connected ailment. He is already all the time bedridden, and her mother is here, and parents is also too old. And there was a helping and one brother was there, and brother also passed away due to illness. And later on, and in those period of time, she was also under mental depression, and she could not pursue the matter. And her court advocate also given no objection certificate that she cannot take another case. That is why there was a miscommunication in between the advocate and the party. And because of the miscommunication, this petitioner should not suffer. And what is there is a when the case can be admitted on merit, what is the harm in admitting the sufficient ground this allow because I have filed a revision petition against them. Discharge of the boy who was very much involved in the case. Because of her, this incident has happened. Otherwise, I do not know this this person first. Her and his husband, the person, this the person who has been discharged in this on 27. This her first wife. He's the person behind this incident. That is why her trial is very much important. As per this whole investigation process has been manipulated by her because police say he should be. There is no search, even no search situation has been made. Although there is a sufficient ground to file search it against her. That is why there was a to raise the matter before the higher court. There was a delay because of that. These circumstances, what I have submitted before this honorable court. That is why my submission before this honorable court.
What were the charges against her? Which sections?
Charges against her is a lordship. There was previously it was previously it was under section 376 is against her husband, and 417 sitting is and 109 was there. And this accused person, the co-accused, this Tamal Nagum has been discharged by the this court, although she has not been searched. When law says when the person is not searched, the court has no power to discharge.
Yes.
That is why this case may be admitted, condemnation delay may be admitted, and matter may be placed for hearing on marriage.
What do you say?
May I please, Lordship?
Yes.
Lordship, here in this case, the petitioner has filed an application under section 5 of
Limitation Act for condoning the delay of 565 days, Lordship.
Yes.
With regards to the order passed by the learned trial court dated 7/10/2025, which is a discharge order of the co-accused person. Lordship, it is admitted fact that the Honorable Supreme Court has time to time has stated that delay while taking up the case under Section 5, liberal approach has to be done. However, Lordship, the delay has to be day by day delay, day to day delay has to be explained by the applicant or the petitioner. Every delay has to be explained. However, here in this case, a huge delay of not at all been explained by the petitioner. As such, it cannot be admitted, Lordship. Lordship, here in this case, the criminal revision petition number 10/24 is with regards to challenging the impugn order which discharges the co-accused person. Lordship, co-accused person is a lady, wife of the main accused person. The allegation against the main accused person is rape, 376 IPC. And Lordship may kindly come to page number 30 of this criminal revision petition, main case.
53-0.
Yes. Lordship may come to page number 29, the previous page. This is the charge sheet. Itanagar WPS case number 56/2020 under section 376 417 409 34 IPC dated so and so. The prosecution story of the case is in brief is that on 13/8/2020, a written FIR has been received from so and so, daughter of so and so, to the effect that Vishal Paul Novam make false promise of marriage to her and his wife Tabayal Nabam conspiring against her. The couple conspired against her with second marriage proposal with alleged accused person Vishal Nabam again gain her confidence regarding the sexual intercourse. On 6 May 2029, as a mark of acceptance, Sri Tabayal Nabam allowed her husband to have sexual intercourse with the victim girl. This is the content of FIR. After proper investigation by the IO, page number 30. Page number 30, Lordship. The last para. Under the above facts and circumstances, a prima facie case under section 376 IPC is found well established.
This bail application is in connection with Alopius case number 78 of 2024. Lordship, here, FIR dated 21/12/2024 was submitted by the SI, one Sri Lika John, who himself is the police officers, SI, who arrested the accused person. Here, Lordship, after arrest of accused person, and after recovery of the contrabanded substance, the FIR was written and the case was registered. Lordship may take you to the FIR. As per FIR, from some reliable sources, the police got information about this accused person regarding selling and peddling of the drug. So accordingly,
Page
police.
15.
Lordship.
Page 15.
15. May I read the FIR, Lordship? Subject FIR, sir. I would like to inform you that on 21/12/2024, at around 9:50 hours, an information was received from a credible source that one person wearing blue sweatshirt and black man was peddling drugs at Facto Heritage Celebration Ground, Industrial Colony. Accordingly, the OCPS Alo was informed and a police team constituting of SI Likajon, he is the officer who has lost this affair. Head Constable Yumo Ori, so and so, left the police station to conduct inquiry. On reaching the spot, the suspect was found missing, but after thorough search, was apprehended and brought back at the PS for further inquiry. The suspect was identified as Mogeado, the accused person, arrested accused person, son of so and so, so and so. Subsequently, more information was received that Mogeado had just peddled drugs to another person and was wearing a navy blue colored cross bag during the peddling, which was found missing from his possession at the time of apprehension and had come using a car, a Hyundai Verna bearing registration number so and so. Thus, the police team revisited the area from where the accused Mogeado was apprehended, and after thorough search, recovered a navy blue bag, cross bag, which contained a wallet containing identification cards belonging to accused person, car key of the vehicle bearing registration number so and so, case amount of rupees 9,620, one antique vial, and a syringe. The car, which was parked at the Industrial Colony Road near the Pacto Heritage Celebration Ground, was then brought back in the PS with the key found in the navy blue cross bag belonging to accused person. Then, in presence of the executive magistrate, Kogi Rimi, Circle Officer, Alo Western District, Arunachal Pradesh, search of the police personnel was done before the independent witnesses present. Further, in presence of the executive magistrate, a notice under Section 50 of NDBS Act 1985 was issued to the suspect, Mogeado, and body search and search of the vehicle was conducted. During the search, the following items were recovered and seized in front of the executive magistrate and independent witnesses. These are the materials, Lordship. After arrest of the accused person and the vehicle, they recovered. Lordship, item number 1, suspected heroin in a blue tobacco container weighing 0.76 gram. Lordship, this is the suspected drugs that has been recovered from the vehicles of the accused person.
It is small quantity.
Yes, Lordship. Now, Lordship, the rest are of course not connected to the drugs. But Lordship, what happened? After arrest and search of these vehicles of the accused person, what they have recovered? They have recovered 0.76 grams of suspected. Then this FIR was registered under what section, Lordship? Under section 21A, small quantity, that I can understand. 27A and 27 capital A, Lord. Lordship, may I take you to the 27 capital A?
Here, please. I think that is financing.
Yes, financing and harboring, Lord.
27, no?
Yes, Lordship.
Yes.
27A. Married, Lord.
Yes.
27A, punishment for financing illicit traffic and harboring offenders. The section itself, Lordship, it says about the financing illicit traffic and harboring offenders. But present FIR, in fact, the FIR was filed after arrest of the accused person and the recovered of this suspected contraband, Lordship. Now the question of inserting and the registering offense under 27 capital A does not arise, Lordship. My respectful submission of it. And as on that, Lordship, it's been 101 days. The accused person is languishing in custody. 2 bail applications were moved before the learned special court, which was rejected. The first bail was rejected, saying that there was one person called Nyaju Mori who deposed before the police authority that the Nyaju Mori also purchased some drugs from the accused person. only on the statement of that one Nyajong. I don't know who was Mr. Nyajong. And subsequent bail was rejected because of the lack of new ground laws. So Lordship, my respectful submission, of course, the accused has been arrested on the basis of the recovered and of this small
If it's
quantity.
21A, it's a bailable offense.
Yes.
PP. What do you say? Because
Yes,
prima
ma-
facie, I'm going through the FIR.
Yes, Your Lordship.
I don't find any reason to put the charge under 27A.
Your Lordship, as Your Lordship is well aware that Your Lordship is well settled that the FIR cannot be the encyclopedia of entire facts. Yes.
Of course.
And Your Lordship, the investigation has been carried out, and one of the witnesses has clearly stated that, Your Lordship, from him he has purchased some contraband substance, Your Lordship. This is there in the case diary, Your Lordship.
Okay, fine.
And Your Lordship, so far as 27A is concerned, Your Lordship, that cannot be read only with that particular section, but we have to read the section 2 clause is also there, Your Lordship, because it's concerned with the peddling also. Your Lordship will come to Your Lordship 27A. May I read, Your Lordship?
Yes.
Whoever indulge in financing directly or indirectly any of the activity is specified in sub-clause 1 to 4 of clause 8B of 22, or Your Lordship will come later on, will come to 2. Or however any person engaged in any of the aforementioned activities shall be punished with rigorous imprisonment for a term, shall not be less than 10 years, but which may extend to 20 years, and shall also be liable to be fined, which shall not be less than 1 lakh, but which may extend to 2 lakhs. Now, Your Lordship may kindly come to section 2, subclause 8B, 1 to 5.
Eight.
8B, illicit traffic.
8B, illicit traffic.
Yes, Your Lordship. In relation to narcotic, drug, and psychotropic substance, means cultivating any coca plant or gathering any portion of coca plant, cultivating the opium poppy or any cannabis plant, engaging in production, manufacturing, possessing, sale, purchase, transportation, warehousing, concealment, use, or consumption also included, Your Lordship. Import, interstate, export, interstate, import into India, export from India, or transshipment or narcotic, drug, or psychotropic substance, dealing in any activity in narcotic, drug, or psychotropic substance other than those referred in subsection 1 to 3, or handling or letting out any premises for carrying or any of the activity referred in subclause 1 to 4, other than those permitted under this act, or any rule or made or any condition of license, this part not come. Your Lordship will kindly see 3 subclause 3. Engaging in production, manufacturing, sale, transportation. Your Lordship, sale also come, Your Lordship. He was engaging in sale. There is a prima facie material in the case, Your Lordship, case diary, Your Lordship. As my brother has also submitted that one of the witnesses has stated that from him some substance was suspected substance was
Reiterating
purchased,
the
Your Lordship.
order of the learned court below, Lordship. Only on the basis of the statement, my bail was rejected.
Now, Your Lordship, when
I'm
27A,
not admitting.
now, Your Lordship, when 27A comes, it has to be read along with section 37 of the NDPS Act, Your Lordship.
No, that's what I'm saying. 27 means 37 will come into.
Yes,
play.
Your Lordship.
But then where is the material in the FIR to put this 27A? That's what I mean to say. Because here, when directly or indirectly, any of the activities. So financing is the important word.
Yes, Your Lordship.
Financing. So illicit trafficking, okay, I understand what you mean by reading 8B. Illicit trafficking is described.
Yes, Your Lordship.
But illicit trafficking has to be financed by
Yes,
the accused.
yes, Your Lordship.
So where is the prima facie material to show that he had financed the illicit trafficking? So what did the other witness say?
The other witness, Your
He
Lordship,
only said
yes, from him,
that
he
he
has,
bought.
yeah, he's both from this person, Your Lordship.
so
And
that-
Your Lordship, the selling of the, his statement is also there. He bought from someone else from the Itanagar, and from him again, he bought it, and he is no doubt, he's admitted that he is a consumer also. And here the section also clearly says that consumer also included. And from there, your lordship, he also indulged in peddling, your lordship, selling that narcotic substance to the other person, your lordship.
So selling, can it be said to be financial?
Selling, your lordship, selling for what? For obtaining financial gain, your lordship.
Anyway, let me see the case.
Yes, sir, yes, your lordship. Your lordship will come to page 15, your lordship.
Oh, this is the bill application. Is the-
Oh, this one, sorry. This one. Page- Sri Nyaju Mori.
My name and address, this one.
Yes, it's correct. He said, I have been using drugs since 1 year ago. I started consuming drugs from Itanagar. I met Moga Ado through common friends. And then we exchange our number. Whenever I wanted to take drug, I used to call him and I get this stuff. If it is for the first time, your lordship, it can be understood, but it says whenever I wanted. It is not for the first time, your lordship. And moreover, your lordship, there is other cases also registered against him in the Doimuk PS, your lordship.
We are concerned with this case. There may be other cases. But when the seizure was 0.76 gram,
Yes, your lordship.
then how do you?
Your lordship, it is well settled that your lordship, I will supply the judgment that your lordship, even for the purpose of invoking attracting section 27A, possession of your lordship, the contraband substance is not mandatory, your lordship. It's held by Honorable Supreme Court in many occasions. Yes, your lordship.
Yeah.
So now the quantity is less.
That's why financing, that's
Yes,
why
your
the
lordship.
word financing is used. A person sitting in Delhi or Mumbai
Yes, your lordship.
can spend crores of rupees financing.
Yes, yes, your
So
lordship.
even if nothing is seized from them, they are liable.
Yes,
under
yes, your lordship.
27. But in this case, the seizure is there and there's nothing to show that he's financing. From here, there's nothing to show he's financing. From the statement of this witness also, there's nothing to show that he's financing.
Yes, from him, he has purchased, he's acting as a
Okay,
peddler, middleman.
purchase.
Yes, your lordship.
Purchase, sale, peddling, that is a different thing. Okay. Learned counsel for the applicant. I think it's time.
Yes.
Yeah, we will continue.
Yes, your lordship.
This is an application under section 483 BNSS, praying for bail to the accused person, namely Shri Mogi Adom, who was arrested on 21/12/2024 in connection with Allo PS case number 78/2024 under section 21A small a / 27A small a under bracket and 27A. This is big A. 27A NTPS 1985. Stop. Heard learned counsel for the applicant / accused Shri such and such. Please give me some time to learn your names. Yeah, just write the name. I say such. Who has submitted that the accused was arrested on 21/12/2024 in connection with the above stated above stated case And learned counsel has stated that in the FIR, the objects which were seized from him are number one, suspected heroin in a blue tobacco container weighing 0.76 grams. Number two, 5 number syringes. Number three, empty vial -1 number. Number four, what is this? Mobile. Something. A mobile number, that's just, you just take it from here, okay? Mobile number, such and such, bearing SIM card number 9362956904. Number 5, cash amount of rupees 9,620. Number 6, Hyundai Verna car bearing registration number AS01MA 9060. Number 7, Hyundai Verna car key. And number 8, navy blue sling bag. Stop. He has stated that the alleged contraband substance, heroin, which was seized from him, weighed 0.76 grams, which is of small quantity, and hence it is a bailable offense. Stop. Learned counsel also states that the IO has erroneously charged him under section 27A, big A, okay, 27A of the NDPS Act, which is punishment for financing illicit traffic and harboring offenders. Stop. He has strenuously argued that the FIR dated FIR is dated 21/12. FIR dated 21/12/2024.
Yes, Lord.
Nowhere shows that the accused was indulging in financing illicit traffic or harboring offenders. So, he has stated that he has already filed 2 bail applications before the learned special judge Allo. However, both the bail applications were rejected on the ground that there is a witness by the name of Shri Nejum Ori, Nyajum, Nejum Ori, who had stated before the police that whenever he needs drugs, he used to get the same from the present accused person, and that even on 21/12/2024, as he wanted drugs, he had called the accused person and bought drugs for rupees 500 from the accused. Stop. Therefore, the accused, being a habitual offender and also a drug supplier, and the investigation being at the initial stage, the learned court below had declined bail to the present accused person. Stop. learned counsel therefore prays that Section 27A NTPS Act has been wrongly charged against him, and Section 21A NTPS Act being a bailable offense, comma, he prays that he may be granted bail at this stage. Stop. I have also heard learned PP, she such and such, appearing for the state, who has produced a copy of the case diary and has submitted that the accused person has been selling drugs and indulging in drug peddling for a long time, and he has other cases pending against him. Stop. He has referred to the statement of one Shri Nejum Ori during the investigation, wherein the said person had stated before the IO that he has been using drugs for the past 1 year, and he had met the accused person through common friends and they exchanged numbers. Stop. Whenever he wanted to take drugs, he used to call the present accused and get the stuff. Even on 21/12/2024, he stated that he had called the accused person as he had come to Alo for some work and bought drugs worth rupees 500 from the accused person. Stop. Learned PP therefore states that there is a prima facie case against the accused person for dealing and trafficking in contraband substance, and therefore he objects to the bail application at this stage, as the investigation may reveal more involvement of the petition of the accused person. Stop. Yes.
Your Lordship, in rigor of section 37 will also attract your Lordship. As per my
37,
submission.
yes, yes.
sir.
Yes, learned PP therefore submits that section 37 of the NTPS Act is attracted in the present case, as the accused person has been charged under section 27A of the NTPS Act. So, that's fine. I have considered the submissions of the opposing counsels and I have also perused the case diary, including the FIR dated 21/12/2024. On going through the same minutely, this court is prima facie of the view that the contraband substance which was seized from the accused person is of 0.76 grams heroin, 0.76 grams heroin, which is small quantity and accordingly is a bailable offense. Stop. This court has also not been able to find any material from the records to show that the accused person has been indulging in financing the illicit trafficking or harboring offenders in order to attract the provisions of section 27A of the NTPS Act. Stop.
There are two
Accordingly-
27A provision, 27 capital. There are two 27A. Lordship.
Oh, this one is 27 capital A.
Capital.
27 capital A. It's okay, we will make the corrections also later. This court is therefore of the view that the present case being a bailable offense, comma, the accused person is entitled to be released on bail at this stage. So accordingly, this application is allowed. So the accused person shall execute bail bond of rupees 30,000 with one local surety to the satisfaction of the learned special judge NTPS Alo. So, the learned special judge shall also enclose any other conditions in order to secure the presence of the accused person during the investigation and the trial. Stop. With this.
My lord,
observation-
And last, your lordship, the observation made in the FIR
Yeah,
will
yeah.
not have any effect on the
Yeah,
trial.
that-
Yes.
It is made clear that the observations made by this court are purely prima facie in nature and shall not have any persuasive effect on the findings of the learned trial court.
Yes. Deeply obliged.
Deeply obliged.
After the petition, your lordship. Your lordship, the survey report is completed dated 10th March 2025.
Service of notice upon to. What is this IA for?
So I for delay of
Delay,
coordination for delay of
Uh,
329 days.
continuation of delay, yes.
Yes.
So you are appearing for
I'm people of ship.
PP?
Yes.
Okay, okay. So any objections to the delay or, but the other respondent is also not appearing, huh?
Yes, Lord.
Your lordship,
How long has it been? 10-3. 10-3. I think we may have to appoint the legal aid counsel.
yes, sir.
Yeah, please, right. Office note dated 10-3-25 indicates that notice upon respondent number 2 has been received from the office of the PP on being transmitted by the OC of Basikat PS. Therefore, notice on respondent 2 is complete. However, none appears for the respondent number 2. Learned, who should we appoint? Do you have a list of legal aid counsels?
Megas.
Yeah, because. You just suggest someone. Because I don't know. This is for districts.
Or
How about this Christina Ehring?
no idea, Lordship.
She's there as panel advocate for the High Court Legal Service Committee.
Lordship, direction may be given to the registry to appoint.
The registry is directed to appoint an advocate from the legal aid panel as amicus curiae for the respondent number 2. The state is represented by the VP. What about lower court records? Records have come. Not yet. We have to check. Call for the records from the court of which court?
Pasigat here.
From the Court of Sessions Judge Basikat. And this is the matter on receipt of the SCR.
Your Lordship, maybe listed after 1 week.
Excuse me,
Maybe listed after 1 week.
after 1 week.
Yes, Your Lordship.
Isn't that too soon? Anyway, let's try them. Listed after 1 week.
Your Lordship, service is completed.
Yes.
My lord, this matter may be fixed on this Thursday.
Thursday.
This is in her lips.
Your Lordship, there is an order on last occasion that the interim that I have prayed for on the last date, it would be considered only after the completion of service.
Completion of
So
notice.
Yes, Your Lordship. Therefore, so date may be fixed because every month, the interim amount is being deducted directly from the salary of the petitioner. So it would be futile if
Oh,
it's,
this is maintenance.
yes,
matter.
maintenance.
I received the copy recently, my lord, and some pages are missing in fact. And
You
there's,
give them.
yes,
Yes.
I have asked for this Thursday, my lord. You can go to it.
Notice is complete in this case and learned counsel such and such appears for the respondent. Both respondents, 3 respondents are there.
Yes, my lord. 2 are minor.
Oh, okay, for all the respondents, okay. List the matter after 1 week.
On Thursday, if possible, Your Lordship, on Thursday.
Thursday. Thursday will be
My lord, Wednesday, next week, my lord. Wednesday. Next week.
next week. 9th. 9th. Wednesday is 9th.
Okay, Your Lordship, in this case, the interim that has been awarded may be suspended till the listing of the matter.
No, my lord, this is the case, in fact.
Yes, yes. Then the entire case will become infructuous if we do that. That's why we're going for early hearing now. 9th. 9th, yes, 9th.
Obligation.
Yes.
Lordship. This is a criminal petition for washing under section 528 BNSS. Lordship, this matter may kindly be put up for admission hearing for the next step.
LC has come, no? The scanned copy of trial court report has been received from the CGM Basikat. Stop. The parties are represented by the respective councils. List the matter after 1 week.
2 weeks.
List the
After
matter
break, after.
after BU break.
Yes.
List the matter after BU break for admission hearing.
God bless.
Yes.
May it be your Lordship. My lord, this is an appeal, and in the pending appeal, my learned counsel, friend Mr. Dicky Panging, he is somehow not available today. But then IA, he has no objection if I press the IA. I'm just giving the background on about which the appeal has been filed. What has happened?
You'll appear.
Yes, in IA, Your Lordship.
On the IA. Today, main appeal cannot be heard because my learned friend senior is not available.
Okay.
So what has happened in this case? There is a village authority under the local act, which decides disputes, land dispute. Now, in the year 2006, there was a land dispute between the two parties. And the village authority, which they in the local language called Keba, has decided that the land will be divided amongst between the two parties in 50-50 equal share. That was in 2006. Then we were aggrieved. We filed an objection before the Deputy Commissioner. That was pending. No decision was taken.
Against the Kepang decision, the appeal lies to the DC.
Appeal lies. We filed in fact, at that time, we filed only an objection and seeking review of the order. That is not the submitted today. I'm just giving the background in which the IA is filed. So we filed an objection or review application before the DC. That remained pending for some time. In the meantime, this 2021 Act, that is the Arunachal Pradesh Civil Courts Act, has come into force in 2021. Now, Act itself provides that if any such application or appeal is pending before the Deputy Commissioner, that will be sent to the Civil Court. And depending on the pecuniary and territorial jurisdiction, it will go to the appropriate court. It may be either Civil Judge Junior Division, it may be Civil Judge Senior Division, and it may be District Judge also. So that way the appeal was, although initially it was sent to the District Judge, but considering the pecuniary jurisdiction, it was sent to the Civil Judge Senior Division. Civil Judge Senior Division has dismissed our appeal. That dismissal took place on 5/6/2023. 5/6/2023.
Civil Judge Junior.
Civil Judge Senior Division.
Senior.
5/6/2023. Against that, we preferred an appeal before the District Judge. Before the District Judge, Your Lordship, the petitioner, in fact, I am in the IA, I am applicant, but otherwise in the revision petition, I am the respondent. So the revision petitioner, before the District Judge, where our appeal was filed, raised an objection of maintainability on the ground that under Section 15 of the Arunachal Pradesh Civil Courts Act 2021, second appeal is not maintainable. Because original decision was of Keba village authority. Then the objection that we filed was treated to be an appeal before the Civil Judge Senior Division. That was the first appeal. Then against that, when we filed a appeal before the District Judge, it became a second appeal. So they raised an objection saying that in terms of Section 15 of the Act, no second appeal is maintainable because it says language is not very clear. That is why the confusion. It says from the order passed by the Civil Judge Senior Division in exercise of original jurisdiction, appeal will lie before the District Judge. I mean, this sentence is from the reverse side. Instead of saying that no appeal will lie from an appellate order, the matter would have been very simple. That sentence is not available in Section 15(3). I'm just reading for the convenience of this Honorable Court. 15(2). Yes. And I'm just reading two provisions. Copy of the extra. I think extra copy is available. You have? I think they have an extra.
So we have, Madam, we have, I'm sorry, Your Lordship.
Next.
Annex in CRP also, Your
I
Lordship.
think it- Lordship may use this. Section 15.
Appeals. Yes.
15(1) says appeals from the decree or order passed by court of district judge.
Hmm.
Lordship is got?
Yes, I got it.
Appeals from the decree or order passed by the court of district judge and courts of an additional district judge in original suit and proceedings of civil nature shall, when such appeals are allowed by law, lie to the High Court. So if it is allowed, it will lie to the High Court. If it is not allowed, what will happen? Nothing is indicated. This is one confusion. Now, second is appeals from the decrees and orders passed by the Court of Civil Judge Senior Division in original suits and proceedings of civil nature shall, when such appeals are allowed again by law, lie to the Court of District Judge. That means if the order is passed in the original site and if it is allowed, that then appeal will lie to the Court of District Judge. Subsection 2. And subsection 1 says, if it is in the original site, order is passed by the district judge or additional district judge, and if it is allowed, then
Right.
appeal will lie to the High Court. Then
If it's dismissed.
Then subsection 3 says appeals from the decree order passed by a court of civil judge junior division in original suits or proceedings of a civil nature shall, when such appeals are again allowed by law, lie to the court of civil judge senior division of this district. And I'm sorry, I'm saying that if it is allowed, and in fact the language is different. It says if the appeal is allowed, meaning thereby that if the appeal is permissible, not that if it is allowed, if it is permissible. So that way, if we read this,
Such appeals are allowed. Okay.
that means if it is permissible, language is different. If the appeal is permissible, either allowed or rejected, then appeal will lie to the district judge. So in simple language, Your Lordship, if the order is passed by the subsection 3, if it is order is passed by the civil judge junior division, appeal will lie to the senior division civil judge. If the order is passed by the civil judge senior division, appeal will lie to the district judge. If it is district judge, then High Court. So they raised an objection that
Provided that any appeal or civil suits pending in the courts of the commission.
no.
What happens to the suits which were pending in the DC's courts and then the.
There is a provision which says that it will be transferred. Suits which are pending, they will be transferred. Provided that an appeal or civil suits pending in the court of deputy commissioner shall be disposed of by the concerned deputy commissioner under the provisions of the Assam Frontier Administrative Justice Regulation 1945, which is still in force, as expeditiously as possible, but not later than 1 year from the date of coming into force of this act. That means after that, it will be transferred. Next proviso, there is a second proviso, provided further that from the date of commencement of this act, in case an appeal is preferred against the judgment of a customary court in the court of district judge or in the court of additional district judge, as the case may be, the court of district judge or the court of additional district judge may dispose of the same or proceed with the case de novo. This has been amended subsequently. Some amendment. Oh, yes. This was amended. Yes. And in the amendment, yes, it was amended. Second proviso to. The subsection 3 was further amended, Your Lordship. I'm just reading. Provided, it now says, provided further that in case the deputy commissioner could not dispose of the pending appeals in the courts within 1 year from the date of commencement of the Act of 2021, they shall transfer such pending appeal cases to the Court of Civil Judge Junior Division, Senior Division, or Additional District Judge or District Judge, as the case may be, as per the territorial and pecuniary jurisdiction.
So what I am indicating is, they raised this objection that this appeal is a second appeal, and in terms of section 15 subsection 3, second appeal is not maintainable. That contention, that maintainability question was decided against them, holding that appeal is maintainable. Then finally, the appeal was disposed of on merit, whereby the appeal was partially allowed, holding that the judgment and decree we challenged, passed by the civil judge senior division, was set aside, and de novo trial was directed. Against that, they have filed this civil division petition. On merit, they have raised certain points, but otherwise their basic point is the appeal that we filed before the district judge is a second appeal, but in terms of section 15, second appeal is not maintainable. If ultimately upon hearing the appeal, your lordship holds that no, that was a second appeal is not maintainable, then maybe against the order passed in the first appeal by the civil judge senior division, we'll have to come before your lordship directly by way of a revision petition. That will be on merit after a matter. Now, what has happened? They have filed this appeal, and in the appeal, there is a stay of the order passed by the learned district judge. Now, during the pendency, matter could not be heard because sometimes adjournments were also taken by them, sometimes due to paucity of time also could not be taken up. Now, today I am only pressing this IA 79 of 2025. Dr. May kindly take the IA. I'll pray for a very innocuous order without affecting them much. Lordship may kindly, your Lordship has got the IA 79.
Yes, 79.
Lordship may straightway go to page 12, para 13. That the humble applicant states that during the pendency of the aforesaid case before the Honorable Court, the opposite party has abused the stay order dated 12/6/2024 by illegally encroaching upon this land by attempting to change the structure and nature of disputed land. All the grown-up trees planted by the applicant has been felled actually illegally, which are more than 43 years old. Opposite party has illegally fallen the following numbers of valuable planted trees: jackfruit trees 3, Mekai tree, then Jamun tree, then Simul tree. All the trees are valuable lakhs of money as per present day market rate. In this connection, FID so and so has been already lodged before the police station Pasighat for appropriate necessary action as per law. However, no tangible action is initiated. So with these allegations, we filed the IA under Order 13 Rule 1 and 2. Page 14 is the prayer, Your Lordship. It is in the premises aforesaid, it is most respectfully prayed that your Lordship may be pleased to admit this interlocutory application, issue notice upon the opposite party, and calling upon the opposite party to show cause as to why the direction or order civil injunction should not be passed for maintaining status quo ante over the disputed land and property still disposal of the case in connection with Pasighat civil appeal number so and so in matter of so and so. So that is the only prayer. So my prayer before Lordship is, let both the parties maintain status quo till the disposal of the appeal. So it will not affect any of the parties because they came to encroach, but subsequently they left. There was a hue and cry, so people left. But then they can make any other attempt subsequently. So I am only praying that the action may be issued for maintaining status quo, so that no change in the nature and character of the property takes place in the meantime. And on the next day, the appeal may be heard on merit. That is my only prayer.
Yes, it's okay. There's no objection. No objection. Because whatever it is, no one should touch the land
Yes,
when
yes.
it is in dispute.
Yes.
Okay. Learned Senior Counsel, your name?
D. Majumdar.
D. Majumdar, assisted by such Boy. The limited prayer in this application under Order 39 Rule 1 and 2 of CPC is for maintaining status quo over the disputed land and properties in connection with the PSG civil appeal Kebang case number 6/2023 in the matter of no.
That is not required to be written.
Yeah, because it's the main case is here.
Yes, in the main case.
Just say this over the disputed land.
Yes.
Stop.
involved in the revision petition.
It is the case of the applicant that during the pendency of the case before this court, the opposite party has abused the stay order dated 12/6/2024 by illegally encroaching upon his land and attempting to change the structure and nature of the disputed land. It is stated that some grown-up trees which were planted by the applicant has been cut down, some of which are more than 43 years old. The opposite party has therefore violated the said stay order of 12/6/2024 in the said manner by attempting to change the nature of the disputed land. It is therefore prayed that a direction may be given for maintaining the status quo over the disputed land till the disposal of the present criminal petition.
Civil revision.
Civil revision petition.
9 AP of
9
2024.
9 of 2024. So, the learned counsel for the appellant / respondent has no objections to the said prayer. Stop. Accordingly, the parties are directed to maintain status quo over the disputed land in the main civil revision petition 9 of 2024 till the next date. We'll just say till the next date and fix the main case after.
Let them fix this so that, because I come from Guwahati.
Oh. After the Bihu vacation.
Fine. Let it be the first week of May then,
First week of May.
because they found some difficulty immediately after the vacation, Bihu vacation. Let me
If
see.
you want a fixed date, if you're.
It's better that I have it fixed. Yeah. Let it be 30th. 30th, 30.
30th of May.
Yes. And April.
April.
Yes.
Let the civil revision petition 9 of 2024 be listed on the 30th of April. So
Right,
in
same here.
actually, in this, the order should be passed in the main case now. In civil revision 9 of 2024, let the matter be listed for hearing on 30th of April 2025. And this IA will stand disposed last time.
Lordship only mentioned on that day, endeavor shall be made to dispose of the civil litigation.
Okay.
It was already there once.
Okay.
Yeah.
Endeavor shall be made to dispose of the case on the fixed date.
Deeply ordered.
Page 7 of 22, anybody? Item 20.
Yes, Your Lordship, the petitioner side is not present, appellant side, it's a criminal appeal.
Yes, it's a criminal. Then appears for the appellant when the matter is called. Learned PP is present. It's the matter after a week.
Your Lordship, maybe after Bihu break,
It's the matter after Bihu break.
deeply obliged.
Lordship, I'm for the petitioner. Kindly matter may be adjourned for today and may be fixed after vacation. Any fixed date may be given.
On what ground?
Leading counsel is out of station.
Then you should have mentioned, no, during the mention or.
Yes, sir.
Learned counsel for the appellant submits that the leading counsel is out of station and accordingly prays for listing the matter on another date. Learned counsels for the respondents are present. Stop. Prayer is allowed. List the matter for hearing after the BU vacation.
Your lordship, fixed date may be given.
23rd,
Your Lordship, let it be on 24th.
24th.
Yes.
List the matter on 24th
May
April
April.
for hearing.
Obliged.
Oblige.
Mayor Malot. Malot, this application has been filed under section 483 of BNSS for the release of the alleged accused who was arrested on 30/10/2024 from judicial custody at Longding District Jail in connection with Longding PS case number 48/2024 under section 64/96/143 clause 1 subclause F/61 read with section 3 and 5 of Immoral Traffic Prevention Act and section 6 of POCSO Act. So, my lord, basically this FIR that has been registered.
Let the PP get instructions first, no?
Yes, Your Lordship, notice has to go to the
Yes, notice-
victim.
notice has to go.
Yes, my lord. My lord, the notice will be going to the PP only.
Yes, the notification is there.
Yes,
Yes,
so
sir.
then
As per notification 17, Your Lordship. Yes.
what does it say?
Your Lordship, regarding the notice to the victim through office of PP and register post as well.
Yes, yes.
It is in C, Your Lordship. C.
Yeah, because POCSO is there, no?
Yes, Your Lordship.
Third learned counsel for the petitioner, Shri
B. Nyarus.
PNP Nerus and Bini Nerus. This is an application under section 483 of the BNSS, praying for release of the accused person. Stop. Learned PP accepts notice on behalf of the state respondents. Since this is a case under the POCSO Act, let notice be issued to the victim/informant through the office of the PP,
Yes.
to the office of the PP, to be served on the victim/informant through the concerned police station. The petitioner shall supply extra copies to the learned PP. It's the matter of her.
My lord, can it be fixed on 10th of April, my lord?
I don't know whether it will be.
Yes, Your Lordship. It
Notice
will
will
be too
come
early.
when-
Notice has to come and
Will be-
record need to be called.
Records may be also called
Records
for.
also, CD also has to be called.
Your Lordship is,
Already
according,
charge sheeted.
it's, yes, it's for CC, Your Lordship.
Yes, already charge sheeted. And my lord, there is a reason behind it because there already there multiple FIR has been registered.
No, that we will consider it.
Yes.
Call for the records and list the matter on
10th of
20 something after the BU vacation, 21st,
Your Lordship, maybe on 22nd, Your Lordship.
the matter on 22nd April for recognition. For orders.
Obliged, Your Lordship.
Deeply obliged.